Catherine Herridge is standing by. She's been sitting there for a while listening in. She's CBSN senior investigative correspondent, and I know that you have been in the hearing. So I want to get from you sort of your biggest takeaways as you've been witnessing this whole thing.
Well, I want to draw your attention to an exchange we had with the Inspector General, Michael E. Horowitz, just before we headed into the break, and he was asked point blank about the issue of political bias and whether this was part of the intent or motivation for FBI officials, and it somehow explained some of the mistakes or the inaccuracies or the withholding of exculpatory evidence from the surveillance court. And Horowitz said very clearly that on the opening or predication of the investigation, that was done by somebody called Bill Priestap. He's a senior counterintelligence official within the FBI, and they looked at Bill Priestap's communications, his text messages, and they found nothing that smacked of a political bias. So Bill Priestap is the one who opened it, and that's very separate from Peter Strzok. That is the FBI's, whose text messages, along with Lisa Page, have been widely reported on in the press. But what caught my attention is that Horowitz said when you get to the renewal and the application for the FISA warrant for Carter Page, the word he used was it becomes, quote, murky. And that was the first time I had heard him almost open the door to this question of intent and motivation and whether they were acting based on their own personal beliefs. So it's not as clear cut as maybe we'd like it to be. On the predication and the opening of the investigation, they found nothing in the text messages of Bill Priestap that suggested political bias, but he was very careful to say that on the FISA application and renewals, he felt this issue was more murky, so that remains open in his view.
And sort of the other thing we were talking about were these briefings that the two campaigns received, and how the intent behind the briefings at least was dual when it came to the Trump campaign.
I don't think I've ever, in the nearly 20 years that I've worked in this space, seen a situation where a briefing that's designed to give senior government officials sort of situational awareness about a specific threat is then used to gather information on the individuals who are being briefed. What the Inspector General Michael E. Horowitz testified to today, that it was not illegal, if you will, or against the policies, but it was certainly highly irregular, and if I heard him correctly, this is one of the issues that FBI Director Christopher Wray is going to clarify for all involved. The bottom line is that these briefings are designed to protect the decision makers, but in this case, the briefings were used to also gather intelligence about the decision makers, and this was put into something very formal called an FBI 302. This is the formal document of an interview or information that is gathered by a bureau agent.
I think one of the things that sort of surprised me the most about the process is how much was left up to, I want to say, sort of lower level investigators to sort of decide what information to put forward. Particularly when we're talking about, sort of human sources. They talked about, people that they depend on, and that they can sort of that it didn't have to be approved of at higher levels.
Very high up the chain.
Yeah.
I know what you're talking about. The ability to open a counterintelligence investigation, what we've learned from the Inspector General's report, so much of the responsibility rested with individuals within the FBI. There wasn't that necessary sort of going up the chain to the Justice Department for that kind of approval, and certainly that was not required regardless of the targets of any counterintelligence investigation, in this case Carter Page, or whether it was another American citizen. So the FBI has a lot of autonomy, working in the counterintelligence space. One of the reasons that is the case, if I can just kind of give you a little bit of a sort of nerdy, bookish explanation, is that after 9/11, this ability to gather intelligence inside the United States was placed firmly within the FBI, and that was driven by FBI Director Robert Mueller, because the idea was to give the FBI the toolbox to break up domestic terrorism plots or to break up spy rings. So the FBI was given these sort of very broad and powerful authorities and investigative tools in their toolbox. And what we're seeing today, sort of almost 20 years after the fact, is that the FBI had a lot of autonomy, and IG Horowitz found that there just wasn't simply enough oversight, or you could make the argument that the environment has changed and the rules and regulations maybe haven't kept pace with some of these changes. And that's something I think in terms of reform that we will see going forward.
And John Durham came up. You talked a little bit about how John Durham and Attorney General Barr have different opinions on this report.
One of the most enlightening exchanges came about 90 minutes in, and Inspector General Horowitz was asked about this statement from the U.S. Attorney John Durham, who's been running a separate and broader investigation into the origins of the FBI's Russia case in 2016. And Durham said he did not agree on this conclusion that the investigation was properly opened by the FBI. And IG Horowitz said that he had had a meeting with Durham, and in that meeting, Durham said he felt the evidence about this Trump campaign aide, George Papadopoulos, and a possible connection to Russians and an offer of help to damage the Clinton campaign. He said that was sufficient to open what's called a preliminary investigation. But what happened in July of 2016 is they skipped over that preliminary step and they went to a full investigation. And I think for folks at home, they wonder, why does that even matter? And I wondered that too. And then Horowitz said, whether it was preliminary or whether it was full, under the current policies, the FBI still had the ability to run confidential human sources, or CHSs, against individuals associated with the Trump campaign. So it appeared to me that whether it was preliminary or whether it was full, these same very aggressive investigative tools were still available to the FBI, and the decision to use them was based on a limited number of individuals, but fairly low down in the chain of command.
Catherine, we have a little bit of sound from that. We're going to play it.
We met with him in November. With regard to that, we did discuss the opening issue. He said he did not necessarily agree with our conclusion about the opening of a full counterintelligence investigation, which is what this was. But there is also an investigative means by which the FBI can move forward with an investigation. It's called a preliminary investigation. So there are two types of investigations, full and preliminary. They opened a full here. He said during the meeting that the information from the friendly foreign government was, in his view, sufficient to support the preliminary investigation. And as we note in the report, investigative steps such as confidential human source activity that occurred here are allowed under a preliminary investigation or under a full investigation.
Did either Barr or Durham present anything that altered your findings?
No.
So, Catherine, you know, people are going to listen to portions of this highlighted on, like, the evening news, and I don't know if they're really going to grasp the weight of the conversation that's happening here and the importance of the FISA process, but that the fact that it's such a secretive process means it is very, very important that the information that leads to a FISA warrant is accurate. Can you just sort of give us the weight of this conversation?
Okay, well, that's an easy question, isn't it, to throw at me? So what I would say is that there's really no higher threshold for the U.S. government to make the argument to the National Security Court that they should use very aggressive investigative tools to gather the communications of an American citizen inside the United States. Think about that, an American citizen inside the United States. And because it's an ex parte court, which means it's just a single party, I would argue there's an even greater burden on the U.S. government to share the full scope of the information, so information that supports the warrant for surveillance of an American citizen, and then also information that undercuts probable cause or goes against that application. And the findings of the Horowitz report is that when there was evidence that undercut the FISA application for Carter Page, that information did not get to the surveillance court in a timely fashion, and some information, like the fact that he had a relationship with the CIA providing information, that information never got to the court. because it's alleged the FBI lawyer altered that communication, altered that email, so it said, in fact, that Carter Page was not a source for the CIA. So the standard for the information is very high in terms of accuracy, and the standard is very high in terms of providing both sides of the argument for the warrant and against the warrant. And again, you're talking about using the most aggressive investigative tools to gather intelligence and the communications of an American inside the United States. These capabilities were built after 9/11 to disrupt domestic terrorism and to break up spy rings. That's how powerful they are. So to understand the gravity of the case that's being made today is, I think, to consider all of those factors.
That was perfect, Catherine. Thank you so much.